must get a good lawyer. But that's becoming increasingly difficult, if not impossible. If we are defending ourselves from the government, we find that lawyers quickly take our money and then tell us when the ship is sinking that they can't help us with that because they're an officer of the court. Ultimately, the only way for us to have even a snowball's chance is to understand the rules of the game and to come to an understanding of the true nature of the law. The attorneys/lawyers have established a secure virtual monopoly over this area of human knowledge by implying that the subject is just too difficult for the average person to understand, and by creating a separate vocabulary out of English words, otherwise common usage. While it may at some times seem hopelessly complicated, it is not that difficult to grasp. Are lawyers really smart as they would have us to believe? Besides, anyone who has been through a legal battle against the government with the aid of a lawyer has come to realize that lawyers learn about procedure, protocol, never about the law. Consider also that the framers of the Constitution wrote in language simple enough that the people could understand, specifically so they would not have to be interpreted. So again, we find, as in many other areas of life, that the buck stops here. It is we who must take responsibility for finding and putting to good use the truth. It is we who must claim and defend our Yahweh-given rights and our freedoms from those who would take it from us. It is we who must protect ourselves, our families, and our posterity from the inevitable intrusion into our lives by those who parasitically live off of our labor, skill, and talents. Today, we are going to start breaking it down of what's really going on in our court systems, so we can really, really have a chance to stand up against these people and how the UCC is connected in all of this. Behold, I send you out as sheep in the midst of wolves. Be wise as a serpent and harmless as a dove. Today we are going to start dealing with law that we are up against. Public law versus public policy. So, what we have to do is figure out what is the difference between public law and public policy. Well, when people go in the courtroom and they be bringing in these Supreme Court rulings and everything, they wonder why the judge just just doesn't hear it and turn it over and everything. But see, they don't have to adhere to any Supreme Court ruling before 1938. And the reason why they don't have to listen to anything before 1938 because public law was turned over to public policy back in 1938. And so the only Supreme Court rulings that they would have to adhere to is everyone that came after 1938. Now we're going to take it to 1938, and let's see what happened in 1938. And we're going to bring it back to the Erie Railroad. I found that in 1938 was the year of the Erie Railroad versus Thompson's case of the Supreme Court. It was also the year the courts claimed they blended law with equity. I read the Erie Railroad case. A man had sued the Erie Railroad for damages when he was struck by a board sticking out of a boxcar as he walked along the side of the tracks. The district court had decided on the basis of commercial negotiable instruments law that this man was not under any contract with the Erie Railroad, and therefore he had no standing to sue the company. Under the common law, he was damaged, and he would have had the right to sue. This overturned a standing decision of over 100 years. Swift v. Tyson in 1940 was a similar case, and the decision of the Supreme Court was that in any case of this type, the court would judge the case on the common law of the state where the incident occurred, in this case, Pennsylvania. But in the Erie Railroad case, the Supreme Court ruled that all federal cases will be judged under the negotiable instruments law. There will be no more decisions based on common law at the federal level. So here we find the blending of law and equity. This was a puzzle to me as I put these pieces together. But I quickly understood that all the courts since 1938 were merchant law courts and not common law courts. There were still some pieces of the puzzle missing. And if you define Title 28 U.S.C. 3002, Section 15A, it states that the United States is a federal corporation and not a government. So a corporation is going to be under commercial and contract law. And see, common law will reside under the Constitution, public law, common law. But commercial law is actually designed under, moreover, of contract, equity, and commercial. Fortunately, and then later when I went, did you know that America is a bankrupt nation? It is owned completely by its creditors. The creditors own the Congress. They own the executive. They own the judiciary, and they own all of the state governments. Take a silent judicial notice of this fact, but never reveal it openly. Your court is operated in admiralty jurisdiction. Call it anything you want, but do not call it admiralty. Admiralty courts. The reason they cannot call it admiralty jurisdiction is that your defense will be quite different in the admiralty jurisdiction from your defense under the common law. In admiralty, there is no court which has jurisdiction unless there is a valid international contract in dispute. If you know it is admiralty jurisdiction and they have admitted on the record that you are in admiralty court, you can demand that the international maritime contract to which you are supposedly a party and which you supposedly